Adil, you can start recording. Okay, a very good afternoon, everyone, and a warm welcome to this forum entitled What is Expected of an Expert Witness? My name is Rusmawati Muhammad, the Master of the Academy of Medicine of Malaysia, a professional organization representing medical specialists in various specialties in the country and currently embracing 13 colleges and 24 chapters. So co-moderating this session with me is Professor Chan Yu Kuen, a council member of the Academy and a senior consultant anesthesiologist. Now, Professor Chan has been helping AMM, together with Milton Lum, to spearhead the training of medical expert witnesses. Now, without doubt, we are seeing more and more medical legal cases in the medical landscape in this country. And with each case, the services of a medical legal expert are very much needed to assist the courts and resolve the issues surrounding the case. There is, however, a dearth of expertise, and despite efforts to improve the situation from the Academy as well as other organizations in this endeavor, we're still lacking experts who have the skills to perform the task of an expert witness. So we are indeed privileged and honored to have with us this afternoon 4 very prominent panelists to give us their views on what is expected of an expert witness so that we can set the correct perspectives from the very beginning for all those who subsequently set foot in court as an expert witness. So let me briefly mention the outline or the flow for this afternoon's forum. We will start with the perspectives from our 4 esteemed guests who will share their valuable insights before we open the forum for questions. So it gives me great pleasure to introduce the first speaker for this forum, Dr. Milton Lum, who is a consultant obstetrician and gynecologist. He has held leadership positions in national and international organizations and was an elected member of the Malaysian Medical Council for 27 years. Milton was also director of a medical indemnity organization and has given more than 120 expert opinions. So now let's hear from Dr. Milton Lum. Milton, the floor is yours.
Thank you, Professor Rose. I have made a recording so that we will not subject ourselves to the vagaries of technology. So can I request Adeline to play the recording of the presentation?
Okay.
I'll stay around to answer any questions or any comments later on. Adeline, good afternoon, Young Arif and distinguished panelists, ladies and gentlemen. This is my presentation on the doctor's perspective. I have to declare that I have been a previous member of the board of a medical defense organization and have advised other medical defense organizations. I've also provided expert opinions in more than 2 decades at the request of doctors, patients, private hospitals, and a public hospital, and I've made more than 50 expert testimonies in the High Courts of Malaya, Sarawak, and Sabah. The views expressed do not represent that of any organization that I am or have been associated with. If any legal advice is necessary or is required, the services of a competent professional should be sought. Now, this is an outline of my presentation. Now, before that, I think one should remember that expert opinions is required in many circumstances, both civil and criminal, as listed in this slide. What is expected from an expert witness from a doctor's perspective? There are only 2 expectations. One, is there a high probability of successful defense? And secondly, whether there are any fundamental principles of medical practice that should be defended. And if so, what is the probability of success? Who is an expert? This has been defined in the Evidence Act, and they state very clearly of persons who are specially skilled in the law, science, or art, and in our instance, it's the science. The Evidence Act also gives an example of what is an expert. The Medical Council's Guidelines for Expert Witness defines an expert as someone who has special knowledge, skill, experience, training, or education on the subject to which his testimony relates. And such knowledge, skill, experience, training, or education must be demonstrated or shown before the witness may testify as an expert. The qualifications of an expert are listed in the MMC's Expert Witness Guidelines. Essentially, the person has to have appropriate expertise and experience, has to be familiar with the duties of an expert, and have no actual or potential conflict of interest, and is willing to appear in an adjudicating body, be it the court, the medical council, or other disciplinary proceedings. The role of an expert is also specified in the Medical Council's Code of Professional Conduct. And I'd like to quote, a practitioner may be requested or required to provide expert opinion in court, and such opinion must be unbiased and honest, and be bereft of conflict of interest, and confined to the practitioner's area of expertise. It is unethical for a practitioner to demand a percentage of the costs or damages awarded by the court, and to make the attendance fees contingent upon the favorable outcome of a matter in which he appears as an expert. This is stated very clearly in the MMC's Code of Professional Conduct. The General Medical Council of the United Kingdom has also got a section on expert witness, and it states, and I quote, "You will need to provide an expert opinion on whether a doctor has fallen short of what could be expected of a reasonably competent practitioner. If so, you will need to explain in what ways and to what extent." The Medical Protection Society, of which some practitioners in Malaysia are members of, states very clearly, and I quote, "The primary function of a medical expert is to guide the court to a correct decision on questions falling within that expert's specialized field. An expert should aim to produce a report that is freestanding, which means that the reader must be able to glean the key issues in the case, understand the evidence available, and reach a clear understanding of the range of expert opinion without needing to look at any other document. Most importantly, the expert should be independent and objective. There is absolutely no role for a hired gun who's seeking to influence the outcome of a case to suit their own interests. Now, there are certain expert opinions which are unwanted. This is when the expert, so-called expert, is lost, confused, unsure, unclear, perplexed, disorientated, or bewildered. And worse still, in the next cartoon, and I quote, "I know nothing about the subject, but I'm happy to give you my expert opinion." The MMC's Expert Witness Guidelines came about in 2013. Before that, I'd like to remind everyone of the Medical Act 1971, which was amended in 2012, regarding the disciplinary jurisdiction of the Council. Particularly, Item 2, which states that the Council may exercise disciplinary jurisdiction over any registered person who has been alleged to have committed serious professional misconduct as stipulated in the Code of Professional Conduct and any other guidelines and directives issued by the Council. The MMC's Expert Witness Guidelines was adopted by the Council in 2013 and amended in 2016 and 2019. The guidelines are for those who instruct, for expert witnesses themselves, and for expert witnesses in legal proceedings and disciplinary inquiries, including the MMC's inquiries. Why did the MMC feel that it was necessary to provide guidelines for expert witness? This was because the MMC received several complaints from the judiciary and the legal profession about the unprofessional conduct of purported expert witnesses in court hearings. I'll give you an example next. This was a case that was reported in 2013. The facts of the case are as stated here. Patient essentially was admitted to the hospital with a right ectopic pregnancy, which was managed conservatively. She was discharged and then readmitted and had a right sapropingectomy for leaking ectopic. Post-operatively, she developed collapse of the lung, pneumonia, and septicemia, and transferred to Johor Specialist Hospital. And she was again readmitted and developed bed sores and discharged with oxygen and tube feeding. On 3rd September, she was readmitted to the hospital and died 2 days later from sepsis secondary to pneumonia and bed sores. The expert witness in the court hearing commented on pleadings. He was quoted as saying, because the patient was treated at specialist level, no complaint can be made because of the treatment rendered. And he was also quoted as saying that the patient's constant pain and vaginal bleeding together with empty uterus and gestation sac can be features of early pregnancy, threatened miscarriage, normal uterine pregnancy, incomplete miscarriage, hemorrhagic corpus luteal cyst, bowel syndrome, swollen fallopian tubes, even the result of addition. He admitted that, and I quote, in public hospitals such as HSA, the ultrasound for scanning has no high resolution, and that in the absence of a high resolution scan, diagnostic laparoscopy is the definitive diagnosis method. This is what Judge Abdul Rahman Sabli, who is currently the Chief Judge of Sabah and Sarawak, had to say about the expert. With respect to DW4, that is the expert, his evidence does not inspire confidence at all. The distinct impression I get is that he was more concerned with defending the actions of the ONG doctors at HSA rather than to assist the court in finding the truth. Therefore, where his opinion is at divergence with opinion of the plaintiff's experts, I prefer the opinion of the latter as being more credible and reliable. They impress as witnesses of the truth. I will now go on to the MMC's expert witness guidelines. It states very clearly in the guidelines that the principles of the MMC's good medical practice guideline also apply to experts. And these are the principles of good medical practice that are listed in this slide. The MMC's guidelines states very clearly the responsibilities of the expert witness, and I quote, the duty of the expert witness is to assist the adjudicating body on matters that are within his expertise, and he must maintain neutrality at all times. This means the expert witness has a duty to act independently and to be honest, trustworthy, objective, and impartial. The expert witness must make sure that any report, written or evidence given, is accurate and not misleading. This means the expert witness must take reasonable steps to check the accuracy of any information given and to make sure that all relevant information is included. If an expert witness changes his opinion at any time, such change or changes should be communicated immediately to the adjudicating body and the other parties in the proceedings. The MMC's expert witness guideline also deals with the issue of conflict of interest. A registered medical practitioner involved in the management of the same patient as the registered medical practitioner in the legal proceedings or disciplinary inquiry shall not appear as an expert witness in such legal proceedings or disciplinary inquiry. If there is any matter that gives rise to a potential conflict of interest, such as any prior involvement with one of the parties or a personal interest, this shall be disclosed to the instructing party, the opposing parties, and the adjudicating body without any delay. The registered medical practitioner may continue to act as an expert witness only if the adjudicating body decides that the conflict is not material to the case. Now, we all know the judgment in Zulhasnima and Dr. Kupulavani, where the federal court decided that it is now the courts, rather than a body of respected medical practitioners, which will decide whether a patient has been properly advised. And the same court decided that for the expert opinion to be acceptable to the courts, it must be capable of withstanding logical analysis. What did the federal court mean by that? They quoted from Lord Brown Wilkinson in Polito versus City and Hackney Health Authority. And what the court expected is stated very clearly in red at the bottom of this slide. The judge, before accepting a body of opinion as being responsible, reasonable, or respectable, will need to be satisfied that in forming their views, the experts have directed their minds to the question of comparative risks and benefits and have reached a defensible conclusion on the matter. We all realize that there is a pendulum swing from Bolam to Bolito and to Rogers, Fufiona, Sohasnima, Montgomery, and Hitchcock, where medical paternalism has given rise to patients' informational rights and autonomy that is not dependent on medical judgment. Now, with regard to writing an expert report, there are certain guiding principles when writing expert reports. They are independence, honesty, trustworthiness, objectivity, impartiality, and accuracy. The MMC's guidelines has advised on expert report contents. They said that the expert report should contain the expert witnesses' qualifications, details of any literature or material relied on in making the report, and a statement setting out the issues in which it has been asked to consider and the basis upon which the evidence was given. And if applicable, state the name and qualifications of the persons who carried out any tests which the expert witness has used for the report, and whether or not such tests have been carried out under the expert's supervision. They go on to state that where there is a range of opinion on matters dealt with in the report, the range of opinions have to be summarized and reasons have been given for the expert's opinion. The expert is expected to give a summary of the conclusions reached and the statement of the belief of correctness of the expert witness opinion. The expert also has to give a statement that the expert witness understands that in giving his opinion and report, his overriding duty is to the adjudicating body and that he has complied with that duty. Similarly, the Medical Protection Society has given guidance to its members with regard to expert witness opinion and reports. And I quote, "Only comment on matters within your expertise. Comment on each question or allegation of negligence separately, quoting the question or allegation whenever possible. Where the question or allegation appears to repeat or overlap with another or seems misdirected, explain why and refer to other relevant paragraphs. And most importantly, justify the conclusions reached by reference to the evidence in the case, your specialist knowledge, and any published references you relied on," unquote. They go on and state, when dealing with an issue on which there are a range of opinions, provide reasons for the views expressed and state those opinions. And where you take sides in an area of factual dispute, explain why you favor one version over another. And where there is evidence undermining your opinion, outline the evidence and explain why it is not persuasive. The bottom line, ladies and gentlemen, is what would the expert report be like if instructions were given or payments were made by the opposing party? And if different, the advice is do not take the case. There are some avoidable errors in expert opinions and reports, and they are listed in this slide. One is the usage of medical jargon, biasness, not connecting the dots, not dealing with contentious issues, sequencing, and references supporting opinion should be relevant and time-specific, numbering, and not showing the expert's human side. Where there are different versions of expert opinions, this occurs when additional documents are made available at a later date, and opinion may have to be amended. One has to ensure that every opinion is dated and check which version has been tabled in court, and that the affidavit is signed with the Commissioner of Oaths. When it comes to court testimony, every expert knows that the process involves examination, cross-examination, and re-examination. And the evidence, although usually technical, is not always easily understood by the judge or lawyers who are laypersons. Issues, particularly contentious ones, may be submerged in detail, and one has to be prepared to justify the opinion and accept other logical opinions, and ensure that there is a distinction between statements of opinion from statements of fact. And one has to resist any apparent attempts to testify on matters outside the area of expertise of the expert, and respond to provocative questions or remarks accordingly. If questions are asked in such a way as to prevent disclosure of relevant matters or to prevent completing answer to a question, then the judge's assistance is needed. And one has to listen carefully to each question and answer honestly, and put aside any concern that personal feelings, their skills, knowledge, and professional standing are not given due acknowledgement by the court. I think at the bottom line, it's important to remember that respect begets respect. I'm giving two examples of so-called experts going off on a frolic of their own. The first case was a judgment by Justice Muhammad Firoz Jafril Puguna and Dr. Lim Su Hao. This was a case of a Rohingya refugee who had a spontaneous vaginal delivery, and the suturing was left to a staff midwife who found a pocket in the anus. A vaginal examination by a senior medical officer found no tear. An examination under anesthesia about 5 hours later, there was a 4th-degree tear found, and the perineal repair was performed with a colostomy done. No information was provided to the patient. The expert, so-called expert, from the Ministry of Health sat with the Federal Counsel at the bar at trial. This is what the judge, who's now in the Court of Appeal, had to state in his grounds of judgment. And I quote, "I wish to state that I found the following conduct of the defendants and witnesses in defending the case appalling. The testimony of DW9, who despite being given permission to sit at the bar table to assist the defendants to understand the medical issues which arose from the evidence of the witnesses called to testify, had taken the role of instructing solicitor to the defendant's counsel instead of the independent expert, as required under Order 40 of the Rules of Court 2012. DW9's unsubstantiated testimony that the plaintiff's vaginal issue was fribble and caused the 4th-degree tear, and his ingenious that there are good and bad guidelines, wherein the Klang Hospital guidelines is a bad guideline. The matters listed above are non-exhaustive. Similarly, in another case of Iris Noharna Afia versus Dairul Aman, the facts of the case were: medical officer carried a vacuum extraction after 15 to 20 minutes of the patient pushing because of maternal exhaustion. Shoulder dystocia was documented by the pediatrician, who was not called as a witness by the defendants. The medical officer did not document shoulder dystocia. The hospital and medical officer claimed there was no shoulder dystocia, and the baby had brachial plexus injury and required surgery at 2 and 4 years of age. Permanent brachial plexus injury that is more than 2 years is usually due to shoulder dystocia and or excess traction at delivery. Judge Faisal Jamaluddin, currently at the Court of Appeal, stated in her write-up on the grounds of judgment that Dr. Z, based on the medical report prepared by R2, the defendant, more than 5 years after appellant's birth, concluded that the vacuum-assisted delivery undertaken by R2 was due to maternal exhaustion. Under cross-examination, Dr. Z said that she thought R2's medical report was part of the contemporaneous medical records relating to the appellant's delivery. Dr. Z admitted that she was unaware that R2 had prepared the report more than 5 years after the appellant's birth. This is what the MMC's guideline had to say with regard to this matter. The expert witness must make sure that any report, written or evidence given, is accurate and not misleading. This means the expert witness must take reasonable steps to check the accuracy of any information given and to make sure that all relevant information is included. Ultimately, ladies and gentlemen, the court decides which of the experts' views and opinions, whether all or partial, is the more likely one. The expert's duty is to assist the court in helping the court make a decision. Now, I've written down here some essentials for experts. I think an expert should have a basic understanding of medical negligence, consent, contract, and for OBGYNs, maternal and fetal rights. The expert has to remember that the duty is to the court, MMC, the adjudicating body, no one else. The expert has to be up to date in his or her specialty and able to write succinctly, to be able to meet deadlines, and has to have a commitment to being available for trials. There are some specialists who write expert reports and insist that they do not have to go to court. This is clearly unacceptable. The expert has to be able to decrypt files, and the expert has to have an impeccable filing system for correspondence and trial dates. The expert has to have somewhere to store the records and sufficient time to read, research, and write a report, to be able to deal with the follow-up comments and questions, meetings with counsel, meetings of experts, and attending trial. The expert has to understand that the expert report should follow a more or less standard format and has appropriate administrative support. The expert has to take cognizance of a number of laws and guidelines. One, the rules of court, the Evidence Act, the Medical Act, the MMC's guidelines for expert witness, and the MMC's guidelines on medical records and medical reports. There are some pitfalls for experts, and I make no apologies for putting this slide up. Anyone who oversteps the responsibility as an expert risks damage to reputation and integrity. It risks a complaint to the MMC, and in other jurisdictions, they risk a civil claim, although this has not happened in Malaysia. The expert has to ensure that he is not close to the subject of the report, either a friend or previous colleague, trainee, to assure complete objectivity. And the expert has to be involved in all details related to a case, and that all this involvement has to be completely confidential. There is no discussion with colleagues or anyone else. These are the references that I referred to in my presentation. And thank you very much for your attention. I look forward to hearing and answering the questions that you may have. Thank you.
Thank you, Milton, for an excellent overview of what an expert is expected to do. We're going to keep all the questions and discussions to the last. And I have now the pleasure of introducing our second panelist, Mr. Sagadevan. Mr. Sagadevan is an esteemed legal professional and partner at the Sean Dillamore Company, and he has been there since 2003. He specializes in dispute resolution, and Mr. Sagadevan's expertise spans a broad spectrum, including insurance law, professional malpractice, and medical negligence litigation. With an LLB honors from the University of London and a certificate of legal practice, he has been a trusted advocate for numerous insurance companies and private medical practitioners. We look forward to hearing your views on what is expected of an expert from you as a lawyer.
Thank you, Professor, for for the introduction. Right? And good afternoon to all the distinguished panel members, and of course, the enthusiastic participants for today's forum. I'm delighted to note the overwhelming response by the medical fraternity to partake in this session. Right? Hopefully all, if not most of you, would play a role in the decision making as an expert. Right? I must emphasize here, there is a dearth of experts in various specialty, and both the claimants, on behalf of both the claimants as well as the defense. Right? And we have a lot of difficulty in securing experts, especially in certain particular specialty, and hopefully all of you will, at least most of you will eventually take on the role of an expert. Right? What I propose to do I've prepared some slides as well. Right? I shall provide a summary of what is the lawyer's perspective, and within the short time of 10 to 15 minutes. Right? Of course, there is going to be some overlaps between my presentation as well as that of Dr. Milton and Justice Vernon. Right? There could be. Right? And what I've done is that I've intend to break up my slides into two portions. Right? Firstly, is what is a starting point, right, for an expert, and the second part is what is expected from the perspective of a lawyer. Right? So without much ado, I'll take you to the first slide. Right? The starting point. Elaine, can you move to the second slide, please? Yeah. See, basically, evidence are two categories. Firstly is the factual evidence, and the second one is the opinion evidence. Right? What is factual evidence and what is opinion evidence is defined in the Evidence Act. Right? As far as factual evidence is concerned, it includes anything, state of things, or relation of things capable of being perceived by the senses. Example, that a man saw something is a fact. Right? Whether the other example which I can think of is whether a particular antibiotic was prescribed by the medical practitioner. Right? That's a question of fact. It relates to factual evidence. Right? Primary facts are facts which are observed by witnesses and proved by testimony. Right? And what is opinion evidence? That is under Section 45 of the Evidence Act. I think I don't want to go into the details of that. Dr. Lum, Milton Lum has already highlighted Section 45. Second slide, Ellen. Next slide. Thank you. In a summary, when the court has to form an opinion upon a point of foreign law or science, and we are, as far as the medical profession is concerned, we are talking about science, right, or art, the opinions upon the point of the person specially skilled in that science are relevant facts, right? When you're talking about relevant facts, we all know that when hearsay evidence, if you come and narrate an event in court saying that I heard from so and so, right? This is what actually transpired. That is hearsay evidence, and it is inadmissible, right? But the exception to the hearsay evidence is opinion evidence, especially in these particular three areas: foreign law, science, or art, where there is an exception under Section 45, where opinion evidence relying on hearsay evidence is admissible, right? Next. Yep. Interpretation and scope of Section 45, science or art, expression is capable of wide interpretation. What amounts to science or what amounts to art, right? The case on point is Chandrasekharan. It's a very old case, but it's still relied on. The expression science or art is elastic enough to give a liberal interpretation, right? Leong's case, the scope of the term has been widely construed, include all subjects of which a course of special study or experience is necessary to the formulation of an opinion. You will realize that I've highlighted two criteria. The first one is special study. The second one is experience. All right? So next slide, please. Yeah. I think Bolam's case has been touched by Dr. Milton, right? And also the second case as well, right? Basically, in a nutshell, a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular art, right? I like to pause here for a while. Responsible body of medical men skilled in that particular art. What this case is talking about is that there can be two responsible body of medical men, right, giving the giving different opinions, right? As long as either one it comes from the responsible body of medical men, the court can accept one or the other, right? And Bologna's test has been applied in Malaysia in numerous cases. Of course, Dr. Milton has also highlighted Bologna's case. There is a gloss added to Bologna's test by Bolaito, where the court says that, look, you can have 10 experts coming to court to give evidence, but at the end of the day, we will decide which to accept based on the logical analysis test, right? So your expert evidence must withstand logical analysis by the presiding judge or the court, all right? Next, please. Yeah, now that is the starting point, which I've dealt with in a very nutshell form or summary form of what are you required and so forth, all right? Now, what is expected of an expert from the perspective of a lawyer, right? Or for that matter, even the court, right? Criteria is an expert must be skilled in his field either by special study or by experience, right? The more scientific or complexity of the evidence sought to be proved, the more extensive and detailed will the court and the counsel inquire into the qualification or experience in a particular field of art or science, all right? Here, it's very important to note that, look, all experts, when they're giving evidence in court, they must establish that they are an expert in that particular field, either by special study or by experience, all right? And how do you do that? It's by way of a CV, curriculum vitae, and that curriculum vitae will be subjected to scrutiny by both the lawyers as well as the court, right? As an example, for example, the lack of qualification or experience will affect the weight of evidence, but not admissibility. Although you may not have the sufficient qualification or experience in that particular field of expertise, but end of the day, that evidence, your evidence, it's still admissible, but it will affect the weight of the evidence. The lesser the qualification or experience, the lesser the weight will be given, right, compared to your opposing expert, if that expert has all the qualifications or experience of up to 10 years, right? A classic example will be, take a neurosurgeon, for example, an expert 1 year in practice, right? And on the other side, we have an expert who's in 20 years practice. Of course, I'll come into the issue of independence, biasness, and all that in a short while, right? Just per se on these particular facts alone, right? Unlikely the 1 year experienced neurosurgeon will have the sufficient experience, right, in giving expert evidence in court, right? So evidence his evidence will be admissible, but the court will evaluate the evidence to see if he is experienced enough to give such evidence, right? That will be a simple example which I can think of. Next slide, please. Next slide.
Adeline,
Wait,
can you move the
I,
slide?
I cannot move the slide. Okay,
Yeah.
sorry, wait.
No mind. What I'm trying to emphasize in the earlier slide is there must be some evidence of qualification or experience in the form of a curriculum vitae and so forth, all right? In the case of Wong Chok Xiao, it's a 1965, also an old case. This is what the court has stated. Yeah. Thank you, Adeline. May I, with respect, suggest that to avoid confusion, the expert witness should give his evidence as follows. He should first state his qualification as an expert. He should then state that he has given evidence as an expert in such cases and the evidence has been accepted by the court. I must qualify this statement here as is done by the court itself. The letter criteria, i.e. that he has given evidence in court, is not necessarily the primary considerations, right? We have had experts coming to court for the first time, all right, and he has provided CV and so forth to show that he has sufficient experience. And there's been cases where the courts have accepted it, although he has not given evidence in court, which has been accepted by the courts in other cases earlier than the present one. Next slide, please. Yeah, the expert is expected to give evidence of his opinion under Section 51 Evidence Act, whenever the opinion of a living person is relevant, the grounds of this opinion is based are also relevant, right? When you're talking about what we are trying to emphasize, I'm trying to emphasize here is that as far as Section 51 is concerned, right, the opinion based on the certain, for example, medical records and so forth, right, the grounds on which his opinion is based are also relevant, right? Again, the next indent. No, sorry, the same slide, please. Experts can rely on extrinsic materials. When you're talking about extrinsic materials, we're talking about example RCOG, guidelines on shoulder dystocia, literatures, articles, and all that, peer review journals, right? And preferably the external material should be referred and annexed to the opinion, right? I must emphasize here, it must be referred. Sometimes I get opinions, right, especially from the other side, where they do make reference to certain articles and certain literatures, right? But these literatures are usually not annexed to the opinion, right? So we normally have to go around searching for the opinion. And I have had cases where I had to examine the expert asking for these annexures, these literatures which has been cited as in the opinion, right? And I'll have to stand it down for a while, 5-10 minutes to read through it and consult my expert regarding regarding the authenticity as well as whether the literature is acceptable to the medical profession. So it takes a lot of time, right? So it's very important. Any extrinsic materials referred to in the opinion, please annex it to the opinion itself for ease of reference, but not only by the lawyers but also by the court, because this document, the opinion, need to be filed in advance, right? The court can expect to be challenged. Sorry, the expert can be expected to be challenged and tested on the extrinsic materials, right? I've just stated that we want to know whether the particular literature is relevant to the facts of this particular case. If it is relevant, I, for the defense, would want to see how I can discredit that particular literature. Of course, the other expert or the other side may come and say that, look, why it is relevant, right? So the experts can be challenged, right? So make sure the literature cited are peer-reviewed journals or reviewed and so forth, and it is credible literatures or articles, right? Next slide. Yeah, experts should not give conclusions on matters which are eminently matters for the court to decide. The court forms its own opinion and is entitled to reject the conclusion of expert witness, right? So what I'm trying to say here is that whether a particular doctor or medical practitioner is negligent or otherwise, it's an issue for the court to decide, right? You set out your opinion or what a responsible body of medical opinion should do. And at the end of the day, the court will evaluate entire thing, including the facts, opinions, and so forth. And the court comes to a conclusion whether there is negligent or not, right? Closingham's case, expert witnesses only give opinion evidence, but the court is free to draw its own conclusions from those opinion evidence. Experts are expected to not give opinions outside their areas of expertise. I think Dr. Milton has already touched on that. Experts must make it clear that a particular question on an issue falls outside his expertise, right? This is also Dr. Milton has touched on it, right? I've had a couple of cases, right? Very rare cases where experts come to court and say, for example, he is an ONG expert, but he also gives evidence insofar as the anesthetic issue is concerned, right? And that is clearly a no-no, right? And you will be subjected to severe cross-examination whether you are giving independent and unbiased opinion, right? And that will affect your opinion evidence, right? So stick to your specialty, don't stray away. And sometimes you get so excited during giving evidence in court, we get straight away and give comments on other specialty, right? Next slide, please. Yeah. Sorry, before that, experts should be, yeah, sorry. And what is the guidelines, right? This is the national guidelines insofar as experts are concerned. National Justice Compania, this case has been referred to time and again in Malaysia by the Malaysian courts. This is the guidelines. Evidence should be seen, right? Two, one is it should be, Secondly is it should be seen to be independent product, uninfluenced as to the form or contents by exigency of litigation, right? Should provide independent assistance to the court because the expert's duty is to the court, not to the lawyers, not to the parties, right? By way of objective, unbiased opinion in relation to matters within their expertise. See, this thing is being emphasized time and again. Must state the facts or assumptions upon which his opinion is based, right? He should not omit to consider material facts which could detract from his concluded opinion, right? We are normally experts are given the medical records, and in some cases, as far as my practice is concerned, I also provide the statement of facts which contain the entire facts by the plaintiff or the patient, and I also provide a copy of the defense which sets out the facts of the doctor or the defendant, right? Because we all know medical records are sometimes not complete, right? Although they could have some material facts, right? There are some number of facts which will be missing from the medical records, and these are supplemented by the statement of claim prepared by the claimant and the defense prepared by the defense, right? These are documents which is given to the expert, and in his opinion, he should identify the source of the fact where he is eliciting from, right? And preferably, he should also give, because we all know medical records are voluminous, right? And preferably, and it is, if I may use that word, it is a must to state the page number of the medical record for ease of reference. Otherwise, you will end up being in court for 3 days as opposed to 1 day. Right? Next. Expect to state and make it clear when a particular question or issue falls outside his expertise, right? Your expertise. If insufficient data is available, this must be stated with an indication that the opinion is no more than a provisional one, right? Sometimes we all take opinions in advance, right? Because of the time factor, right? There could be insufficient data or facts available. So the expert should state that this is a provisional opinion subject to 1, 2, 3. These are the documents I need to conclude my opinion or to come to a conclusion, right? If after exchange of reports, an expert changes his views, I think Dr. Milton has touched on that, on a material matter, having read the other side's expert report for any other reason such change should be communicated to the other side and when appropriate to the court, right? We cannot hide this opinion because eventually this will come out, right? And it will reflect very badly if you don't change your opinion, right? Because opinions can change, right? Two, one is after receiving additional documents, and secondly is during the course of trial, the plaintiff, rather the claimant or the doctor may give evidence in court, which may be material to your initial opinion. So it could change, right? So you must accordingly change your opinion as well, right? It can be either in favor or otherwise. Right. Next, please. Duty to the court, I think we all know this, right? Expect to act honestly and remain impartial between the parties. The fact that the expert is paid for their services and is instructed by one party in general leads to the assumption that the expert is likely to exhibit a tendency to give evidence which favors that party. He is seen as a partisan advocate rather than a disinterested advisor, right? I've referred to this as a case from UK as well, Kala Holmes Limited. An expert should not consider that it is his job to stand shoulder to shoulder through thick and thin with the side which is paying his bill. Most witnesses would not be prepared to admit at the beginning of cross-examination that he was approaching the drafting of the report as a partisan hired gun. I think Dr. Milton has touched on this, right? One classic example is that this doctor who's coming an expert, ONG expert, and I must regretfully state that he is passed on. All right, he was in court and then he approached the lawyer for the other side and said that, look, I am being paid to do this in court, right? And he was thoroughly cross-examined subsequently by the other side, right, regarding what he meant by the statement which he made outside of court. Was he a hired gun, an expert who is prepared to stay what is necessary for payment of money, all right? And that did not reflect very well on him, all right? Next slide, please. Gafur's case, comments by the judge. Dr. A seemed to ignore the facts in the available records. His opinion is not supported with proper reasoning from the available facts of the case. Dr. A stated that he was a senior consultant at the hospital, but was gazetted as a specialist, right? This goes into his credibility here, all right? And because he has provided a CV of setting out a lot of things, right, which is eventually found not to be true. And not qualified for the position of a consultant, nor qualified to be designated as a senior consultant. To claim such an assertion cannot be a mistake, but an untrue statement. By being untruthful, he is not a reliable witness, right? So your CV is crucial, is very important that your CV is proper and you say true facts, right? Next slide, please. Same case again, Gafur's case. In cross-examination, he asserted that he could not read the examination and treatment notes. Firstly, his CV, there's some shortfalls in his CV, now his evidence. And during his re-examination, he was able to read or decipher them without difficulty, right? The demeanor of him in this respect created doubt in his evidence that he is an impartial witness, right? He has taken into consideration facts which were non-existent and irrelevant, which had adversely affected his opinion, which this court finds to be doubtful and suspicious whether it was a fair opinion or one which is biased. Right? So I don't need to explain this. Next slide. Procedural expectations, right? Earlier, I've already given the expectation by lawyers. CV has to be complete, truthful, and so forth. What is expected during the course of your evidence, by cross-examination and so forth. You could be cross-examined. You got to rely on materials that have been supplied to you, right? Literatures, you can rely on literature and so forth, right? As far as the procedural expectation is concerned, compliance with Order 40 rules of court is mandatory. Primary duty of an expert is to assist the court. I think we all know that. Evidence must not only be independent, but should be seen to be independent. If a party has a special relationship with the expert, this must be disclosed in the expert's opinion, right? Requirements of an expert evidence at trial must be in written form, signed or exhibited in an affidavit sworn or affirmed by him, right? Must state that he accepts full responsibility for the report. Next, please. Yep. An expert's report shall give details of qualification, give details of literatures, contain statements setting out the issues, right, which he has been asked to consider, and the basis upon which the evidence is given, right? Pausing here for a while, what normally the lawyers do is that based on the statement of claim and based on the facts set out in the defense, right, especially in the statement of claim, what the allegations are, right, what is being commented on by the claimant, that regarding the shortfalls by the doctor, right? So we will frame it as an issue, right? Say, for example, whether there was an examination into the blood test report as an example, then the doctor will identify that as an issue, and then he will make comments based on the materials provided to him, right? And he will supplement his conclusion on those facts, on literatures or any articles or passages from textbooks. Right. The next one is contains statements setting out the issues he has been asked to consider based evidence. If applicable, state the name and qualification of the person who carried out any test or experiment which the expert has used for the report. Right. Sometimes, especially in rehab cases, they do get other specialists involved to conduct certain tests and experiments, and you must identify what were the tests and experiment carried out and who carried out it, those tests and experiments. Right. Next. Yeah. Where there is a range of opinion on the matters dealt with in the report, summarize the range of opinions and give reasons for his opinion. Right. So you must give reasons why you are coming to the conclusion of that particular opinion. Contain a summary of the conclusions reached, contains a statement of belief or correctness of the expert's opinion, and contain a statement that the expert understands that in giving his report, his overriding duty is to the court and that he complies with that duty. Next slide. Still, Rule 4. A party may, with leave of court, put an expert instructed by other party written clarification questions about this expert. As I stated earlier, expert reports are disclosed or filed and disclosed between the parties or the counsels or lawyers of parties in advance, right? And we have the right to go through the report in advance. This is all to save time, right? Instead of me cross-examining and keeping the expert on stand for 3-4 days, right? These are issues which can be clarified at the very outset and done away with, and the expert need not be in court for so many number of days, right? An expert's answer to the written question shall be in writing and provided within such a time as the court may direct. If the expert does not answer or does not adequately give, in the opinion of the court, answer to the questions, the court may make the following orders. Next slide. Yes. That the party who instructed the expert may not rely on the evidence of that expert. The expert, this is quite bad, right? Because the claimants rely on experts, and at the 11th hour, he has no experts. Then it can be damaging to both, to the claimant as well as to the defense. That the expert who instructed the expert may not recover the cost of the expert from this one. The second alternative order the court may make, that the expert is to answer or provide a better answer to the questions, as the case may be. So it is an alternative options available to the court. Next slide. The court may direct a discussion between experts for purposes of requiring them. This is what we call hot tubbing, right? The court will ask both the experts to sit before the hearing or before the trial starts to thrash out the issues in the proceedings. One. Secondly is whether the experts are able to reach an agreement on any of the issues, right? Following discussion, the court may direct the experts to prepare a statement showing the issues which they have agreed, the issues on which they disagree, all right? So these disagreed issues are the one which will be tried eventually, right? Where the issues are all agreed, right? There is no reason to proceed with the evidence of the expert of either side, right? The contents of the discussion shall not be referred at the trial, right? Sometimes we can say that, look, as far as the disagreement is concerned, why I am disagreeing to this particular issue, why the other side is agreeing to this particular issue, and what is my opinion on that particular issue, right? And what is the actual discussion taking place will not be referred at the trial, right? The lawyers, I mean, I must concede here, right? There has been cases where the expert divulge discussions during hot tubbing to the other side's counsel, and that results in a mess during the course of the trial, right? So it should be avoided, right? When you're expert, you are representing a claimant or a defense, right? And if the lawyers would ask you what was discussed as far as issues which are disagreed is concerned, right? Never divulge that in the discussion between the two experts, right? Next. Yeah. Howard Federal Solicitors 2024 recent case. This is as far as you must be clear and concise in the presentation of your opinion evidence, right? Be it whether written or oral evidence in court. The ability to communicate clear and concise reasoning is likely to be a key factor influencing the judge's decision, and is a major difference between the best and the worst experts, right? We have experts coming to court, and like Dr. Milton has stated, they use a lot of medical jargons, right? And they go on a tangent of own, they go on the peripheral issues, and the main issue is something else. They rarely touch on the main issues, right? And we are all lay people, judges and the lawyers, all right? And if the expert is able to communicate clearly and concisely, putting forward his opinion, all right, that will help all of us very much. And it will also help the litigants as well, right? Never assume that the court knows anything more than that. I must also add, never assuming that the court or the lawyers knows anything more than that which comes with the most basic common sense, right? Most judges do not want to get bogged down with masses of technical information, right? You're talking about medical jargons and so forth, right? User-friendly reports that tuck away unnecessary or peripheral information into appendices make it much more easier reading and understanding, right? I just touched on it. If you need to include peripheral information or issues, all right, you can attach that as an appendix to the opinion. Right. Next, please. Yep, that concludes my perception or the lawyer's perception of what an expert should be, or what he should do, or what should not do when he's giving both written and opinion evidence, right? And as Professor Chan has stated earlier, I'll take any questions at the end of the session. Thank you very much, ladies and gentlemen.
Right. Thank you very much, Mr. Sagadevan, with the very clear messages and a comprehensive overview. So we've heard from a medical practitioner, a lawyer. Now let's hear the perspective from a judge. So it gives me great pleasure to introduce the next panelist, Datuk Vernon, who is a distinguished legal figure in Malaysia, known for his contributions as former federal court judge. Now, all through his career, he had various significant roles, including serving as a judicial commissioner and later as a high court judge. So beyond judiciary, Datuk Ong has also been involved in legal education, serving as a visiting lecturer and participating in numerous Bar Council committees on law reform, ethics, and professional development. So I'm delighted to invite Datuk Vernon Ong to share his perspective. Datuk?
Thank you, Professor, for the introduction, and good evening to everyone. Having had the benefit of hearing from Dr. Milton Lum and Senior Counsel, Sir Sagadevan, I will therefore not touch on the areas covered by them, which are comprehensive and thorough. So the forum is entitled, "What is Expected of an Expert Witness?" Being a bit naughty, I thought maybe I should reframe the question to say, what can an expert witness expect in court? So I'll put you now in the witness stand as an expert witness in court. The first thing that you can expect is to be cross-examined by the opposing counsel rigorously on the opinion that you have just given in your evidence in chief. And by rigorously, I mean vigorously. Number two, you will also expect to be closely scrutinized by the judge, the trial judge hearing the case. The trial judge will be observing your demeanor, how you answer questions, how you give your opinions, how you refer to the various documentations in the course of your evidence in chief. And more importantly, how you handle yourself under fire during cross-examination. It's not easy, it's very unpleasant, but it is a test of your veracity and your credibility as an expert witness. So this brings me to the fundamental point that as a witness of opinion, you come to court as an expert, number one. You come to court to give your opinion, number two. It sets you apart from an ordinary witness who comes to court to give evidence of fact, what he heard, what he saw, or what he felt. Like taste, I tasted something bitter, something like that. So as an expert witness, you are entitled to give your opinion on a certain issue, of which you are supposed to be a specialist in, knowing that you have the specialized knowledge, skill, and expertise in the particular area of practice. As such, you can expect in court to be challenged as to your opinion. Is it backed up by any authority in the form of articles? You have to be able to show that the articles are peer-reviewed. You have to be able to show that articles have been published in credible medical journals. It would not help or assist you if you come up with a publication no one has heard of, or where the credibility of that journal in particular is highly questionable. So these are the basic ground rules of what you can expect in court. Now, judges who hear cases, as far as I am aware, none of the judges past or present in Malaysia have any medical background, which means there were no lawyers who then took, there were no medical doctors who then took up law and became judges, as far as I'm aware. So you have to go on the premise that the trial judge does not know anything about the case in hand, in particular, the medical aspects of the case. So it's important for you, when you give your evidence, you are expected to give clear, concise opinions. In the course of which, when I read medical reports, there are lots of medical jargons. So you have to pity the poor judge. He doesn't understand what you're saying. How is he supposed to understand when you say comorbid, or idiopathic, or subtherapeutic, or tachycardia? You'll have to look it up somewhere and try to understand what it means. And if you throw such legal jargon as a witness in court, when you say, oh, the symptoms were impressive. Impressive, as I understand, and from a medical point of view, is worrying. But from a natural and ordinary meaning, impressive suggests something else. Or, oh, the disease appears to be progressing. Progressing suggests something positive, but it's actually getting worse, isn't it, in medical jargon? Likewise, you say, oh, well, the symptoms in this case are unremarkable. It actually means good in medical jargon, but natural, ordinary meaning, unremarkable means neither here nor there, and so on. Now, if a lawyer were to talk to you using legalese instead of ordinary English or plain words, then you will appreciate how hard it is or how difficult it is to comprehend something simple that a lawyer is trying to convey to you. For example, instead of saying, I agree with what you said, he will say, I concur, I assent. Why not say agree? It's such a simple word. Or if something has been cancelled, he'll say, oh, it's ineffective, null and void, nugatory, vacated. And you say, only if something had happened, the lawyer will say, provided that, you see, the play with words, legalese. And then, for example, you say, can you help me to get the book? A lawyer will say, can you give me some assistance to get the book? Words, words, words. So it is important for witnesses, especially expert witnesses, when they come to court, to remember that trial judges and also lawyers do not necessarily understand the jargon that's peculiar to your particular profession. So the medical profession is an old profession. It has grown and evolved over the centuries, and the terminology that it uses are precise and they mean exactly what they say. So if we remember that words carry meanings, words have meanings. Therefore, when you use words, if you can use words that are more easily comprehended by the trial judge, words that mean what you say without being too much of a medical jargon. I was going to talk about hot tubbing, but Mr. Sagaravan has mentioned about it. Now, hot tubbing may become more and more common in courts because trial judges have found that medical negligence cases tend to be very long, drawn, and complicated because of the issues. So in order for the court to save time, to simplify matters, and to get to the real issues in dispute, the experts of the both parties are required to sit down together, to exchange their reports, to draft a joint report, to summarize their areas of agreement and disagreement. And on that basis, when they come to court to give evidence, a lot of time is saved. So apart from this, I don't really have anything else to say, except that you have to be mindful that when you come to court, again, you come in as an expert and as a witness. So you stand in a special position relative to a witness coming to court giving evidence. So remember, credibility, speak concisely with clarity, and always back up your opinion with credible sources, peer-reviewed articles, and credible medical journals. So that's all. Thank you very much.
I'm sorry. Yeah. Thank you, Datuk Ong, for an excellent sharing of your wisdom. And I would say the brilliant twist you've actually brought to the perspective. They are rare gems, if I may say so. Again, we will keep all the questions to the end. And I now have the pleasure of introducing Datuk Stanley Isaac. He has actually been kept to the last because he is a plaintiff. And he actually is a distinguished barrister of the Middle Temple and legal expert as well. Currently, he's a notary public at Messiah's Isaac and Tan, and he also serves as an arbitrator and adjudicator at the Asian International Arbitration Center. With a distinguished career in Malaysia's judicial and legal services, Datuk Isaac has held key positions such as Senior Federal Counsel, Deputy Public Prosecutor, and Head of Litigation at the Attorney General's Chamber. And his contributions to the legal field are both extensive and impactful. We'd like to hear your opinion now, Datuk Stanley.
Thank you, Professor Y.K. Chan and Professor Rosmawati, if she is still on. My fellow panelists and all of you who are hearing in on this forum, I say hello. I'm here, I mean, as a panelist, but in the way of a plaintiff in an actual court action, wherein I sued certain doctors and specialists of the General Hospital Kuala Lumpur for and the government, the hospital and the government, for damages and aggravated damages for negligence that caused the death, untimely death of my late wife, Dr. Suzanne Isaacs. Now, I sued them under the broad heading of negligence, in the tort of negligence, but the facts that had borne out before the court shows very clearly that this is not merely a case of simple negligence. It is too nice a word to describe the management of the hospital and the doctors of my late wife. I would consider this, and I've said this, it is gross recklessness, but for the conduct of the doctors concerned, my wife should not have died. She went to the hospital healthy and okay while still serving as a medical officer. Not with the government, but as a just retired doctor. I succeeded in the High Court on both the limbs of damages that I sought. For this evening, I was asked by the organizers if I would come and narrate to the audience of what actually transpired from the time she was taken ill to the time of her death. Now, all this happened in a matter of 5 days. She was found on a Friday evening with an ankle, one right ankle that was swollen to such a size that it raised much concern. And on the following morning, I took her to the medical center called the Tropicana, then called the Tropicana Medical Center near our home. And from there, she had asked to be referred to the General Hospital. After having got her admitted to the hospital, I found that the way that she was dealt with, where within 8 hours of her admission, she had fallen into a coma, and then after about 18 hours later, she was admitted to the ECU, ICU, and she never recovered from there. 4 days after that, she passed on. Now, I would like to, in order that I may not be emotional, I like to read excerpts of the grounds of judgment of the judge who dealt with this matter in the High Court. If I may ask Adeline, would you kindly turn to page 340 of the law report? 340 of the law report, paragraph 10. Can you enlarge it a little bit? Can you enlarge that passage which is in box? Thank you very much. On arrival, this is what the doctor had, the judge had recorded as the background facts. On arrival at the emergency department of KL hospital on the same evening, the deceased was conscious and was able to give a history herself. The deceased had informed the doctors on duty, including medical officer Dr. Shukri Mohammed Safian, and that she had hypertension and diabetes in particular, and that her full medical records were with the KLH. The deceased was also related the fact that she was allergic and could not tolerate certain drugs, including tramadol. She had explained the adverse consequences based on her previous experience in the same hospital some years later. Despite noting this history in the medical record, the deceased was given tramadol that very night. The doctors assigned, sorry, I will go over, can you turn over to the next page, page 341. Sorry, I beg your pardon. Can we return to the previous page? The doctors, number 11, the doctors assigned to the deceased case was orthopedic surgeon Dr. Mr. Sivalingam Rajagopal, and the seventh defendant who was named as Dr. Shukri. These doctors decided to reject the diagnosis, and this is very important. They decided to reject the diagnosis of septic arthritis made from the hospital, the medical center that I mentioned earlier, and made a diagnosis of osteoarthritis. The unfolding events would subsequently show that the decision proved to be fatal to the deceased. Now, the reason why she was referred to the General Hospital, because my wife had asked that she be referred on being told that the consultant orthopedic surgeon of that medical center made a diagnosis of septic arthritis. She was rather shocked by the whole thing, and she said, "No, I want to go to the General Hospital where all my medical records are." And the judge So that was a fateful decision, and I mean that she made, and I feel the same. The next paragraph 12 of that same page says, having made a diagnosis of osteoarthritis, the KLH doctors had also decided to undertake fresh blood investigation. However, it was discovered that the blood sample taken at the hospital had clotted as a result, and as a result could not be used for investigating the deceased's blood parameters. Unfortunately, there was no follow-up, and thus the need to rule out septic arthritis was somehow forgotten. Now, the events as it was that there was no investigation done by the doctors, both these doctors I've mentioned. Rather, they decided that they will do a scan on the following Monday. This was on a Saturday evening. They will do it on the following Monday, which was 2 days later. And in the meantime, all that they did was encase her ankle in a ice bag and told her to rest there until Monday. And in the meantime, no treatment whatsoever was given to her. Even the antibiotics that she was on at that time was taken off. These two doctors also had the blood test results from the medical center, which showed that her white blood cell count was abnormally elevated. And the two doctors refused to accept this diagnosis because they said, no, we cannot accept a diagnosis from a private hospital and act on it. We have to do our own investigation. But no investigation really was done except to do a blood test, and the blood sample that was taken had clotted. On the following page 341, at paragraph 13, paragraph 13, yes. In addition, the 7 defendant, okay, I asked him to even cover her in the meantime while you're doing your own investigation, cover her with antibiotics, but they say, no, we would not do that because we want to wait till Monday to come. And then the second and the second and the 7th defendant, these two same doctors, had then went off for their weekend without assigning any doctor to observe her. In the meantime, as I said just now, they had administered to her this drug for pain relief called tramadol, and they had gone against her instruction or her advice that she's not to be given that particular drug, and nevertheless they had. But in the meantime, they had gone off for their weekend, and there was no one there to observe whether she would react to the thing and what action that should be taken. On the following morning, I left her at 1 a.m. on that early Sunday morning, and she was fine. She was conscious. She was talking with me. We prayed together, and then she ate a sandwich that we brought along. And then I said to her, "I'll come tomorrow after the church service," and she said, "That's fine." At 7 o'clock, I get a call to say that, "Please come. Your wife is in a bad shape." I rushed. By the time I arrived, she was delirious. She was not able to recognize me. She was not talking to me despite my attempt to tell her that I'm here. She was not able to. And then soon after that, while I was still there, she slipped into a coma. And then the rest is history, in the sense that she was later in the day, when my son-in-law, who is also a doctor in the IC, in the in the ICU had come and found that she was not waking up, and he immediately called for help, and she was moved into the operating theater. And what they did was they aspirated her ankle and found that there was a lot of pus. And after that, she was moved to the ICU, and as I said, after 4 days, she passed away. Now, I want then to just move on to the opinion, the expert opinion that were given by two of the very well-known doctors, namely Dr. Chan, Dr. Chan Yo Quen, also known as Professor Y.K. Chan, who just now introduced me, and one Dr. K.S. Dillon, consultant orthopedic surgeon from KPJ Selangor. Now, I did not know them at all, and this is the important factor. I did not know them. I didn't ask them to provide an expert opinion on what had happened. I was told by my counsel that he preferred to call these two, one in anesthesiology, Professor Y.K. Chan on anesthesiology, and Dr. K.S. Dillon in orthopedics. Now, I would like to just read what they have stated in the opinion which the judge had adopted and recorded correctly. And he said at paragraph 97, we are there. He said, after all these care providers, all the care providers in the management of Dr. Suzanne had failed her. The orthopedic team failed to recognize the consequences of sepsis in a diabetic patient. They were extremely slow, a delay of 24 hours to understand the gravity of confirming the diagnosis and putting the correct antibiotics to manage the high-risk emergency situation the patient was in. She was already in a hyperglycemic crisis, and this was also not recognized by the orthopedic team before the anesthesiology team took over the care. Next paragraph, although the anesthesiology ICU team recognized at the time of admission that the patient had diabetic ketoacidosis with the septic arthritis, they failed to resuscitate her microcirculation appropriately with proper fluid management, and allowed her to remain hypoxic in the tissues by allowing her to experience further dehydration with their fluid management. 35 says, in addition, they failed to recognize the consequences of their overzealous ventilation, these are in the ICU, which worsened the microcirculation and did not improve the tissue hypoxia. 36 says the cerebral and pontine infarct are the collective results. The cerebral and pontine infarct are the collective results of failed microcirculation leading to the tissue hypoxia from the sepsis secondary to the septic arthritis in a right ankle, from dehydration secondary to poor fluid management, and from severe vasoconstriction secondary to excessive high ventilator volumes. Cerebral protection should have been afforded from day one after admission into the intensive care by ensuring that the carbon dioxide level was not excessively low, as happened in this case. The disease blood flow to the brain contributed to the tissue hypoxia, which resulted in the infarcts in various areas of the brain. Hypoglycemic crisis occurring in a diabetic patient is rare, but it should not absolve any well-trained acute care provider from managing these patients adequately. They should have solicited the care of an endocrinologist if they had doubts about the symptoms and signs, the fluids and insulin management, and the metabolic abnormality that ensue from the condition. The providers showed that they were managing the patient's problem piecemeal without recognizing the whole picture of what the patient's problem were due to. The efforts in care did not match what the patient needed to survive. They were making gross errors with fluids and ventilation, which ultimately cost the patient her life. I would also like to read excerpts of what the court had recorded of Dr. K.S. Dillon's expert report. And that's on the following page, 98, paragraph 98. I'm only reading 2 or 3 portions of it. Dr. K.S. Dillon made a similar finding in the final paragraph of his report. Mainly, the cause of death was reported as cerebellar and pontine infarcts. The cause of death was most likely due to septic shock. The patient was at a high risk of developing severe sepsis and septic shock, considering her age and multiple medical illness. The patient also had streptococcus pneumonic bacteremia positive culture, which is one of the common causes of severe sepsis and septic shock. Only a prompt diagnosis on the day of admission and prompt initiation of broad-spectrum 4 antibiotics and better surveillance and monitoring of the patient would have prevented severe sepsis and septic shock from setting in. There is absolutely no role of a guarded approach of waiting for fever, which may never occur in an elderly with sepsis and withholding antibiotics till sepsis is confirmed. Nothing will go wrong. If a patient with osteoarthritis of the ankle is treated for septic arthritis, let me read that again. Nothing will go wrong if a patient with osteoarthritis of the ankle is treated for septic arthritis. However, treating a patient with septic arthritis for osteoarthritis can have disastrous consequences. This is what had happened. Management of this patient on admission at the hospital Kuala Lumpur and on the following day, on 21st of December, fails, in my opinion, to meet the minimum standard of care required in management of an elderly patient who is referred to by an orthopedic surgeon for suspected arthritis of the ankle. Then, apart from these 2 doctors which gave evidence for the plaintiff, the paragraph 99 says, on the other hand, the plaintiff had submitted the reports prepared by Dr. Wee Lee Leong of the Department of Anesthesia and Intensive Care Sungai Buloh, and another by Dr. Muhammad Anwar Haji Abdullah Pakar Perunding from Kelantan, Kota Baru. He said the submission was that their opinions were biased and in favor of the defendant, which is their employers. The government is the employer, and it was submitted to the court that they were therefore biased and in contradiction, and they were giving evidence in contradiction of the guidelines that the MMC had provided for experts who give evidence in the court. Now, both these, the report, the expert report given by the Professor Y.K. Chan and Dr. K.S. Dillon reinforced my conviction that I am right in going to court on this matter. Now, even if there weren't these 2 reports, I would have still gone to court. But it fortified my conviction that I am right, that this thing cannot be left off the hook and take the attitude some people take in Bahasa Malaysia, takdir Tuhan. I just could not accept that. And I'm grateful to the two experts who gave evidence on behalf of my case. Now, I want to say what the learned judge had said. By getting the two in-house experts, I think this particular point a bit about making sure that whoever gives evidence must be independent and not in any way in any form of relationship with the party that calls you to give evidence. So he says here in 102, by giving the two in-house experts to conclude, by getting the two in-house experts to conclude there was no negligence, the plaintiff's contention that the defendants were attempting to persuade this court that the defendants had somehow passed the Bolam test. The plaintiff would then have to show that the defendants' expert opinions were not reasonable, responsible, and respectable, and did not stand up to the logical analysis. Simply put, the defendants were endeavoring to misuse the Bolam test. Then the next paragraph says, this court, having read all four reports, is of the view that there is merit in the plaintiff's argument. A responsible expert who understands his duties and obligations under the law would gather all the facts, consider the versions of both sides, address all issues which arise for determination, and provide an objective and truly independent report uninfluenced by the surrounding pressures. I would like now to just finish off by just going to what the judge of that court had held. I will not read all. This is at page 332. Can we have it back at page 332? Now, held up, the evidence showed that the defendant failed to follow up on the blood investigation, and this led to a downhill spiral in the deceased condition. The callous attitude of the attending doctors and nurses, particularly D2 and D7, in failing to ensure that an accurate and speedy diagnosis of the disease ailments were made was one of the aggravating factors which entitled the plaintiff to be compensated for his injury. The negligent act of administering tramadol to the deceased, despite a history of intolerance to the drug, caused the deceased to be disoriented and nauseous, and to suffer prolonged retching on the night of the admission and early hours of the next day. Adequate and proper observation of the deceased during the critical period in the ward was lacking. Finally, as I said just now about the two reports given on behalf of the defendants, in paragraph 6 on page 333, and I will conclude with this, the two reports submitted by the defendants' experts were notably silent on the late and inaccurate entries in the deceased medical record, was skewed towards absolving the defendant of any liability whatsoever. I need to add to that to say that what had been discovered after we had obtained a court order to secure the patient's hospital record showed that the patient's record had been tampered with. The doctors concerned, particularly Dr. Sivalingam, who was the one who caused the tramadol to be given to her, which resulted in her going into a vomiting and dehydrating situation that precipitated her into a coma situation and eventually her ultimate death. They had tampered with it by adding on such things as we consulted with the patient in the night. This is by the specialist, Dr. Sivalingam. He said what has been added on in there, there were quite a number of scribbles into the record. One of which is this, which is something that I did not expect from any doctor, least of all a specialist or a consultant, to do a thing like this. to deceive not just the plaintiffs, but to deceive the courts as well. The court observed this, and he says it does appear defendant experts were no. Yeah, basically that this is what is said here, that the court accepted the fact that the records were tampered with. Ladies and gentlemen, I have heard the other panelists speak on what is expected, and my case is one that speaks loudly to the things that are expected, not just of the expert, but of the doctors themselves. I want to raise this point for, if there is time for discussion. Is it the accepted or the recognized policy of MMC, or of any particular government hospital, or of any private hospital, particularly, let me exclude private hospital, that the report or the diagnosis made by a doctor or even a consultant in a private hospital ought not to be relied on in giving treatment, but rather to wait for their own investigation to be done. This is what had happened here. I mean, there was a diagnosis based on an X-ray and of course superficial investigation of the ankle and the blood results. And with that, the doctor in the consultant in the private hospital had made an analysis or a diagnosis that it was septic arthritis. And when it is septic arthritis, I am advised, and I believe to be true, that it is an emergency situation. You cannot do what as they did here, to defer this thing to 2 days later on a Monday for a scan to be done. Well, thank you very much, Professor Rosmawati and Professor Y.K. Chan. Thank you very much.
Thank you, Dr. Stanley. Thank you very much for the sharing. And I think you ended with a question, which I will ask Milton to answer, because I think it's fair that, your vast experience at MMC also helped to actually really get you to give the best way forward to how we should really be dealing with such circumstances too.
Every doctor to whom a patient is referred has to take cognizance of the referring doctor's diagnosis. And in this instance, if a referring doctor has stated that it is septic arthritis, it behoves the doctor referred to has to ensure that it is not septic arthritis before even considering osteoarthritis.
So some hospitals also have policies, like in emergency department or the trauma emergency, that we do need to take note of a referring doctor's diagnosis, depending on the situation, of course, but in most circumstances, yes, it has to be taken note what others have assessed, and that's based on what they have actually gone through in the testing before they came to the diagnosis. Yeah. So we now open for questions and answers from the audience. Even the panelists can also ask us, or rather the experts here, what things which possibly needs to be clarified also. So I have nothing on the chat, but perhaps YK.
Yeah, I was just going to ask the panelists, what exactly is, what the panelists exactly thinks of experts whose report has actually been submitted and accepted into the court, but is not called as an expert physically into the court by his counsel. What could be possible reasons sometimes of this situation arising? That means his report is accepted by the court, but he's not called in for the cross-examination or for the hearing itself. What could be possible reasons for that? Maybe we can ask Mr. Sagadevan.
Yeah, thank you for raising that question, Professor. First thing is that if the expert has given an opinion report, right, and he decides not to give evidence, the starting point is that he will not be, the report will not be admitted at all because it remains unchallenged, one. Secondly is that he has to come to court, although he affirms an affidavit to say that this is my report and so forth, right? And also to verify that it's true and all that. But admissibility is, it depends on he coming and giving, giving evidence under oath to say that this is report, and then he must be subjected to examination both by the lawyers as well as the court itself, right? Failing which that report will not be admitted. But I'm quite surprised Professor has indicated that it has been accepted. I'm not sure how it can be accepted without he or she coming and giving evidence.
But carrying on with the same question, if
Sure.
let's say the counsel for this expert or this particular case accepts his report and then sends it into court and is accepted, but the counsel fails to call this particular expert to be in the hearing itself. You mean to say then the judge will just throw the expert witness report out?
Yes, that's right. That's right. You see, it's not it is not accepted as such. I may be wrong in hearing your question. An affidavit is filed. It's merely an affidavit, just like a witness statement of the parties itself. It's filed in court, right? And this is for convenience purposes, right? To disclosure of documents and expert reports in advance, right? For it to become evidence, he must come to court and give evidence and be subjected to examination by both the lawyers and so forth. Failing which, it will not be accepted until and unless the other side's counsel agrees to it. He says that, look, I have no issue with this opinion report, or whether it be a prognosis or whether it's on liability or whatever. I have no issue with this report, and you don't have to call that particular maker as a witness, right? So concession is being made, in which event the court can accept it, right? The next issue is whether that particular report is challenged. Answer is no. If it's not challenged, that means it's a credible report. So until and unless the other side waives the need for him to attend, right, that report remains inadmissible.
Okay. While you are on the topic of cross-examination, I have been an expert for a while now, and I find the cross-examination part particularly distressing, of course, as to most experts as well, and I'm sure all would agree. I mean, as a doctor, I'm not quite used to the yes or no kind of question because, you know, if anybody asks me for anything, I have to always feel I have to explain why something or why I say what I said. So I do know that the cross-examination is also for us to be challenged in terms of validity of what we say. But actually, what is expected of the expert itself when they are in the dock itself, you know, during the process of cross-examination, how are we expected to perform? I know most of the time when I'm called, I will stick to what I know of the situation. How I interpret, of course, depends on what question it is. But when I don't agree, I realize that if I say I don't agree, nothing is pursued after that. But of course, the counsel on my side will probably use that particular disagreement to subsequently re-examine me on that same note itself. So I was just wondering if I had been given that chance at the cross-examination itself to explain, it would be kinder for my heart instead of stopping short and saying, You just have to give a yes or no kind of answer. So I would like to figure out, why is this technique chosen? Because it is like anti-medical as far as I'm concerned, because we are never brought up this way.
Okay, YK, I will get Datuk Vernon to answer first, and then perhaps you can also add Mr. Saga. Datuk Vernon, go ahead.
Yeah, thank you. There are two aspects to what Professor Chan said. Number one, about rigorous cross-examination. Number two, about yes and no answers to questions.
That's right.
As a witness in court, either as an ordinary or expert witness, you are under the protection of the court, which means you cannot be harassed or bullied by a lawyer during cross-examination. So your lawyer, or it's not the lawyer who called you to come as an expert witness must be on the alert. If he sees that you are being bullied or harassed by the tone of the voice of the counsel or by the way the questions are put to you, then he should stand up and tell the counsel is harassing my witness and ask for the court to protect you as the witness. You are there to assist the court. You should be protected.
Great.
So you have to remember that. So on that score, you have to work closely with the lawyer or the firm calling you to come as a witness. Then secondly, on the question of yes or no, again, if you work closely with the counsel who will call you as a witness, he must be on the alert. If you're put to answer a yes or no question and you say yes, but the lawyer said, no need to answer, tell me why, then he'll shoot you another question. That your so-called the lawyer who called you must make a note that, okay, I'll have to re-examine Professor Chan on this so that she can explain why she said but. So the lawyer will say, earlier, Professor Chan, during cross-examination, you were asked this question. You say, yes, but could you tell the court why you said but? And then you have the opportunity to explain to the court why you said but. But if your lawyer does not pose the question to you in re-examination, then layman says, sorry lah, you have no chance to explain. Which is why it's very important for your lawyer, or rather the lawyer who called you, to be familiar with your expert report and to be briefed, for him to brief you as to what you can expect as a witness. It's no use when you say yes, but, and then you start looking at the lawyer calling you for help. He can't help you because he cannot stand up and answer for you as well. You cannot ask him to say, what should I say, or make some kind of sign. Sorry, you can't do that. So back to the question, work closely with the party calling you. Get the rules of engagement clear in your mind between the two of you. So you're telling, if I have to say yes, but then you have to remember to cross-examine me, and so on and so on. All right. So that's my perspective as a judge. Thank you.
Great, thank you. Anything to add, Mr. Saga?
Let me say that cross-examination is for me to elicit evidence in my favor. Right? That's a starting point. Right? There's no point me cross-examining and allowing the expert to go on a rampage and killing my case. Right? So the art of cross-examination is that, but it all depends on the lawyers as well as the presiding judge. Firstly, is that in my practice, right, when I cross-examine, I think whoever is participating will be familiar with that. What normally I do is that I will not stop the doctor from explaining, but the doctor needs to answer my question first, right? So I'll put a question, do you agree with me that this is the position, or this should have been the position, right? So the doctor should answer yes or no, I disagree, I don't agree, or whatever it is, right? Then I will give the doctor an opportunity to explain if he says he disagrees, why do you disagree and otherwise, right? That is purely to save time, right? It's not my job for you to elicit explanation from the doctor, right? The explanation of the doctors are, there's always this, justice has indicated, re-examination is where you patch up whatever you need to do or whatever you want to say, right? but it takes time, right? And we all know that eventually when the doctor says that, look, yes, but, no, but, right? So we all know that this question is going to arise during the re-examination stage. That's the reason why in my practice and when I cross-examine experts, I will give them the opportunity to avoid re-examination question from coming up, right? So to answer your question, Professor, is twofold. One is procedure is such that there is the evidence in chief where you give whatever you want to say. Examination, cross-examination is where I want to elicit evidence in my favor of my client, right? Re-examination is to patch up whatever you need to say during the cross-examination, right? Of course, in this overall picture, the judge has an absolute discretion whether to allow you to explain or otherwise. I have had judges saying that, look, no, this is cross-examination. You just say answer yes or no, right? Your explanation will come during the re-examination stage. But I've also have judges where they said, look, eventually this doctor or this expert is going to give his explanation, but as well do it now itself. And the judges have allowed it in the course of conducting the trial. And to cut short, right, it's procedure, one, and secondly is that I don't want an explanation which will jeopardize my case. That's the reason. Right?
Okay, great.
Thank you.
Thank you very much. All right. So Amelia asked, is there a standard template for expert witness report? I will first answer that, and I'll just ask Milton. As far as I know, Milton, there isn't a standard template. But I remember a few times when I actually have been called to write to be a medical witness, the law firm that actually asked me to do this will actually state in the letter of instruction what they want from me. And I will give you just some of these points that would include, of course, starting with a description of my qualification and experience. Of course, you put your CV, summary of instructions that I received to actually be very clear on what I need to do. So they will give me all the documents needed. Then I will actually they will ask me to elicit the facts from the documents and then give my opinion and attaching any relevant medical literature before giving my conclusion. And they actually highlight that the statement that we must do, your overriding duty is giving the opinion to the court and your opinion is independent. So these are some of the standard instructions that I've received so far. Milton, is that what, do you agree, or is there anything more? Yeah.
The contents of an expert report are given in the MMC's guidelines as well as in the rules of court. So what I normally do is I take the chronology as in the medical records, and then depending on what the instructing counsel's instructions are, I will answer those questions if they are, and give my opinion on them. Sometimes legal counsel sends you medical records before they file the case. And sometimes they do not ask you particular questions, in which case I will just address two questions: whether the management of the patient was in accordance with accepted practice. And second question is whether there's any omission or commission that would have contributed or caused the patient's condition. So it depends on the instructing counsel's instructions.
Right, great, thank you. Datuk Vernon, there's a question for you. Is it true judges tend to follow prior judgments and examples? And what particularly he's highlighted is the worrying trend of aggraved damages. So that's one of the things that we want to hear from you. Then we'll follow up with another question after that. Yeah, go ahead, Datuk Vernon.
Thank you. As a general rule, judges in the lower courts are bound by the doctrine of binding precedent. So, for example, if you have a judgment of the federal court or the court of appeal, then the high courts must follow the rulings. on either a certain legal test to be applied or how a section of an act is to be interpreted on certain facts, and so on. That's the extent of binding precedent. But insofar as finding of facts based on the evidence of witnesses, then there's no binding precedent. Every trial judge is the ultimate finder of facts. So for example, if the case starts in the Sessions Court, even if there's a High Court case which may be on quite similar facts, the Sessions Court may make a different finding of fact to say, no, there's no negligence. But the Sessions Court judge must give his reasons. So the only binding precedent is where on points of law, on interpretations of law, and on the legal test to be applied. Now, coming back to the issue of quantum of damages, which now appears to be quite monumental compared to 5-10 years ago. Again, there are certain general principles of law applicable to assessment of damages. But a lot of it also depends on the expert evidence that are given in the course of the trial by the experts on aftercare and so on, which the court will then have to take into account in coming to an assessment. And I believe that because of the high cost of aftercare and the now longer lifespan of patients, so these are factors that are taken into account by the judges, plus the high cost of professional aftercare, which is why the quantum awarded is now substantially higher than before. Thank you.
Right. And very briefly, why is there no cap on the claim of damages? That's one of the questions being asked. Why is there no cap? I know you've mentioned the factors, but yeah, there shouldn't be, right?
Well, there's no cap because it's difficult to set a boundary as to the factual circumstances that may arise. You may have a young baby born passing away after 1 week because of negligence, or passing away after 1 year, or passing away after 2 years. So the pain and suffering during the period of 2 years will have to be taken into account. Or you have the case of a teenager who was subject to malpractice as well. So you have all these various permutations. It's impossible to put a cap. But not putting a cap doesn't mean that it's ad infinitum. No. Judges are constrained that damages are meant to be compensatory. So as to put the parties back in a position as if that incident never happened. Or in the case of a patient who needs long aftercare, special care, special facilities at home and so on, then to put this particular individual in a position where he is taken care of according to a reasonable objective standard. So all these are matters that will have to be considered in court.
Great.
Professor Rose,
Yes, go ahead, Milton.
can I say something on
Please
aggravated
go ahead.
damages from a medical defense organization's point of view? Previously, the courts didn't award aggravated damages. It was only in recent times that it did. And if you look at the cases where they awarded aggravated damages, the conduct of the healthcare facility and all the doctors were indefensible, in fact, appalling. And I think we can do something about that. The medical profession can be more caring, as they should be. And this would reduce the likelihood of aggravated damages being awarded.
Just to add on from where Justice and Dr. Milton has stated, two aspects of the matter, right? There are certain categories of awards where the courts do follow binding precedents or even previous cases. For example, fracture of femur, for example, right? There is some guidelines as to how much, what is the range of minimum and maximum, right? But like Justice have indicated, the problem is future care. That's where if you realize the cases insofar as where the exorbitant amounts have been given, right, which appears to be fair as far as that particular patient or that particular plaintiff is concerned, most of the cases relate to future care, right? And when you're talking about future care, all right, the evidence of rehab specialists and all come into play, and they will make an assessment, including the neurologist, to come and say that what is needed for this particular patient, right? And we all know that lifespan has increased to what, 74, 76 or whatever it is, right? And we have expert reports coming in saying that, look, if this particular patient is well cared for, it could survive the normal lifespan, right? As opposed to those days where they say that, look, taking into account all the injuries and future care and all that, and brain damage or whatever it is, the lifespan can be reduced by 10 years or 15 years, right? But that has gone up as well, right? The lost life expectancy have increased. The medical treatment for this kind of a patient have also evolved into something more, how do I put it, it's more needed, and as well as technology and medical practice have gone to another stage where this kind of a patients can be well taken care of and their life can be prolonged, right? So there are a lot of other factors which the court take into account in arriving at, and the test is always reasonableness. I think Justice have just mentioned it, right? Whether a particular form of treatment is required, if it's reasonable, the court have no choice but to allow it, right? And when you're allowing it, the other factors which I've just mentioned come into play, and that escalates the awards, right? I hope I've answered your question, and together with Justice and Dr. Milton.
No, that's great. YK, you want to continue with the other very brief question? Before you do that, I will just mention that although YK has already highlighted that the Singapore and UK have also struggled with having witnesses, they're actually doing a lot better, because they actually even have a pool, a list of a pool of medical experts who have be relied on, and they've actually undergone some form of actually a course to actually be able to be identified as a medical expert witness. So I think that's what we are learning from them too, and that's why we're actually hoping to have a lot more of a similar session and of the medical expert witness. Go ahead, YK.
Okay. Yeah, thanks for the opportunity. I'm just going to make one concluding statement from what I have learned, not only from here, but from elsewhere as well, as an expert, because I've always been told we judge, but I have kept on to the stand that experts do not judge at all. We are actually helping the court to translate the science of medicine into a form that is understood by the court. And I'm very sure all who are here, including the participants, will agree that what I've just said is true, because most times experts do work that is really very much needed, but most providers don't feel they want to do that work. If nobody does that work, I think the standard of care, the safety in care will all disappear. And we should actually look at experts doing very, shall we say, strenuous, dangerous, stressful work that is very much needed. Otherwise, the standard, as I said, will not be kept. Maybe we should now just go around to all our panelists and ask them to probably give a line or two of what they want the participants to take home. Already we know we're taking home a lot of wisdom, but is there anything we can actually ask from you that will summarize or that you think we should take home as gems to keep for the long run?
We'll start with the order of the presentation. Milton, you go first.
I think every doctor should follow the patient's journey and ask yourself whether you would want to be treated in the manner that patients have been treated. If you have been treated properly and in an adequate standard of care, then that is, you have arrived. Good medical practice is necessary to reduce the amount of litigation.
Okay, thank you. Mr. Saga.
Yeah, I just like to add on from what Dr. Milton has stated. All I want from the experts, from these participants who are present today, is that firstly, is that make an effort to give expert opinion, right? And when I say make an effort to give expert opinion, I meant twofold. One is on behalf of the patients and on behalf of the doctors, right? And it has to be independent and unbiased opinion, because like what Professor Chan is talking about, we ought to have a medical practice which is acceptable to everybody, right? We don't want patients to sue frivolous claims and so forth. We don't want the doctors to, if I may use the loose word, bungle in the course of their practice. That's the last thing anybody wants. And I don't want to go under a scalpel by a doctor who has been cutting and pasting everybody, right? So medical practice has to have certain standards, right? And to achieve that, right, experts are required to come to court and say that, look, this is unacceptable practice, right? And on the other hand, we can have frivolous claims as well, right? This has to stop. So I really look forward to some of these participants to become an expert and meet them in court, and we can have a cordial cross-examination, Professor Chan, with these experts.
Okay.
Thank you very much.
Thank you.
All right. Thank you. Dr. Vernon, go on.
Yes, thank you. I have just 2 points to make. Number one, there are 3 types of experts. The first is a court expert, where the court can, on its own volition, appoint an expert to come as a witness to testify in court to give his opinion on certain areas of his specialty. And the second expert is an expert called by the plaintiff to come to court to give his opinion. The third type of expert is the expert called by the defendant to give his opinion. Now, experts, medical experts or any other experts, including lawyers, we always have differing opinions, isn't it?
Mm.
So it's all right if you come to court and you have a different opinion from your colleague who is sitting on the other side, who will be testifying after you. Just because you have a different opinion doesn't mean that you disagree. It's just that you have a different opinion based on the facts and on the record before you. And you're entitled to your opinion. So this should not discourage potential expert witnesses from the medical fraternity to come to court. And I say this because the court needs to have your assistance as expert witnesses to help the court, to guide the court, to show the court the issues that are before the court. What are the fundamental basic issues, to let the court learn from you and to understand what it is, to appreciate what the issues are, to be able to analyze the issues on the basis of the evidence, of the witnesses and the documentary record, and to be able to come to a fair and just conclusion. So therefore, to conclude, the role and function of an expert witness is very important and never to be underestimated. So if you come to court as an expert witness, take pride, take honor, because you are doing an honorable role in the judicial process. Thank you.
Great, thank you. That was very, very important for us to have that, because yes, a recent discussion was very heated along those lines. Dr. Stanley,
Yes.
your key messages, please.
May I say that medical experts play a very, very useful role, firstly, to assist the court in arriving at a just and fair decision in respect of a case that is brought before the court by the patient or the next of kin of the patient. There need to be fearlessness in the doctors. the experts to come forward and give evidence where it is within their expertise and their knowledge, unless of course they are connected, they don't feel that they are independent. But otherwise, I think any expert, medical expert, who is willing to come should always remember that the call to their profession requires them to assist the court and to assist not only, I shouldn't say that, to the doctors who are being sued, as well as to the patient who has suffered a great deal at the hands of negligent doctors, and also to the next of kin if they have lost a loved one on account of negligence or previous negligence, or in my case, on gross negligence or recklessness, as I would call it. Thank you very much.
No, thank you. Waiki, go ahead.
All right. I'd like to thank everybody, our esteemed panelists, as well as our participants for making this forum such an enlightening one. I myself have learned so much from attending this, organizing this as well. And I'm very sure all my participants, in fact, from the way they have not left, we actually had 124 to begin with, but with extended time, I think less than 20 had left. And most, before they leave, they had actually asked for recording. So it shows our panelists have done a wonderful job with this forum, and it has enlightened not only me and Prof. Rosma Wati, you all have enlightened all of us. And from the questions as well, we know that all of them were very enthusiastic in trying to learn from this forum. And they have even asked for a future topic, and I'm very sure we will get to it once we get ourselves organized. We'd really like to thank all our panelists from the bottom of our hearts.
Yes.
Thank you.
Thank you, everyone. And,
Thank you,
and
Professor.
Thank you.
Yeah,
Thank you, everyone.
Thank you, Prof.
Thank
Have
you,
a pleasant
Justice.
evening.
Thank you,
Thank you.
Datuk.
Hello.
Thank you, Milton.
Thank you.
Thank you,
Okay.
Milton. Thank you,
Arif.
Sajiravan.
Bye-bye.
Raga,
Bye.
And
Datuk
lastly,
Arif.
thank you,
Prof. Rose,
Adlin and the
Prof. Waiki.
Secretariat.
Oh yeah,
I
Adeline,
hope
thank you very much.
everyone,
Thank
yeah,
you, everybody.
welcome.
Take care.
I
Bye-bye.
hope
Bye.
everyone can fill in the Google form for feedback on our end in case you guys have any improvement for us. Probably you guys can fill in the Google form, before you leave.
Yeah. Feedback form. Yes.
Yes, we will really appreciate the feedback form. And after you've got your feedback form returned to us, then you will get your certificate of attendance.
So does that mean we
Well,
don't
that's
get
the
the free?
usual trend now.
Yeah.
Yeah. So
What we can
Professor
do is
Chan and Professor Rose, so does that mean we don't get a free lunch?
we can always
Anytime,
arrange
Prof.
that. No, it's really good.
Yang
We'll
Arif.
have to in the
Fantastic.
physical session. All right, great. Thank you again.
Thank
Thank
you.
you.
Thank
Take care.
you.
Bye-bye.
Bye.
Bye.